on the Zoom.
There's the agenda. I'm going to call the meeting to order and then we'll just introduce you and introductions. I mean,
Sure.
greetings.
Yeah. Greetings and stuff.
Just a reminder, just to state the time when we start. When we, for the minutes,
I know, but what time is it?
Oh. here.
Okay, I got it. Okay. Good afternoon, everybody. The time is now 2:09. This is April 28th, 2023, and I'm going to call this meeting to order. Before we take roll call, I'd like to introduce everyone to Attorney General Douglas Moylan. We have the pleasure of him popping in to say hi to all of us and maybe to say a few words of encouragement as we do our work. Thank you.
Well, good afternoon, everybody. My role here is in recognition of the Criminal Injuries Compensation Committee members. Thank you for doing what you're doing. This commission is decades old now. I remember it vaguely from when I was in the AG's office. Unfortunately, we didn't have as many resources as the government of Guam now has. But I will say that from our perspective, as well as General Barrett Anderson is aware, the compensation and the assistance of the victims is paramount to we as a community to make whole those people that are hurt by others in our community. And I fully support everything that the commission is doing. We are here to provide the additional support as you request us. And I look forward to the next 4 years working with you and trying to further the goals that the commission is setting. Thank you.
Thank you very much, General Moore. That's interesting from general to general. Not too many people call us generals, really, Judge, but thank you for reminding that general to general. Thank you for appearing. And if there's anything also that we can consider for you, we just let the board know, commission know, and go through that. But, thank you for appearing.
Thank you, General.
All right.
If I may be excused.
You
I have to
are.
defer to the chair. Thank you.
Thank you very much. All right, can we do roll call now? I will start with Elizabeth Barrett Anderson, commission member and chair present.
Lisa Flores, Commissioner present.
Honey Mike Chrysostomo, present via Zoom.
Denise Mendiola present via Zoom.
All right, thank you very much. Denise, we thought you were going to be here. That's okay. It's good to have you. It's actually, we can hear both of you very, very well. Can you hear us well?
Yes, ma'am.
Okay, good. All right, very good. All right, with that, we do have a full quorum, and I'd like to turn it over now to Amanda to tell us about our compliance with open government requirements.
Yes, Your Honor. In compliance with the Open Government Act, the first publication of this meeting was effectuated in the Guam Daily Post on April 21st, 2023, and the second publication was effectuated on April 26, 2023. This meeting agenda was also published on the GovGuam Notices portal and the Office of the Attorney General website. For the record, this meeting is also being live streamed on the OAG YouTube channel. And I can go ahead and turn it back to you, Your Honor.
I'd like to also recognize the presence of Deputy Attorney General Fred Nishihira. Thank you, Fred, for being here and helping us out. Fred, is there any particular, or you're here instead of Matt?
No, so
Okay.
Matt wasn't able to make it with you, so I'm glad you brought it up or make it here this afternoon. Something came up at the last minute. I told him that I'd fill in, but I was gonna ask, I'm gonna be sitting literally in the next office. If I could do that, because I need to make a couple calls. She can run over to me. I'll actually put you on YouTube as well, but I might not be listening because I have to call to me.
Well, Fred, I know absolutely how always busy you are, and so I didn't want to just have you sit there. why don't you go ahead, as you suggested, to your office, which is just down the corner.
Yeah.
And if we have any particular concern, we could take a recess and bring you back in.
Okay.
But
Thank you.
otherwise, but if you'd like to stay, you are always
I'll
welcome.
be back anyway, because I'll bring you
Okay.
cold water like it
Oh,
normally.
water,
do.
please, yes.
Okay.
Thank you, Fred. Thank you. All right, Amanda, you've distributed the minutes of our last meeting, and give me the date of that last meeting again. Was that November 20 something?
That the last hearing was held on November 18, 2022. Your Honor.
Okay. And I believe Dr. Flores, you were here. Polly Mike, you were also present. Denise was not present. I've gone through the minutes. I don't have any corrections or changes. Do any of the other commission members have any concerns with the minutes that were provided ahead of time, correct, Amanda?
Correct, that is correct.
Any concerns? We can take a few minutes. You're okay, Dr. Flores? Okay, Polly Mike, are you okay with the minutes?
Yes, I have no concerns on my end, Madam Chair.
All right, then can I have a motion to approve the minutes of November 18, 2020?
I make a motion to accept the minutes from November 18, 2022, subject to correction.
Okay, Polly Mike, please second that.
And I second that motion.
Okay, all those in favor signify by saying aye. Aye.
Aye.
Any opposition? There being none, the minutes of November 18th, 2022 are hereby approved. Okay, we're going to go straight into new business now. I'd like to ask the members just to confirm the extension of my chairmanship. My tenure expired March 31st, 2023, and I'm holdover until the legislature reconfirms me. I had my confirmation hearing. When was that, Amanda? Last week?
I believe it was last Wednesday, yes.
Last Wednesday. And the speaker indicated that she would try to get my reappointment onto the session agenda as soon as possible. So under the statute, I'm a holdover commissioner, but not necessarily a holdover chair. So I just want to get the commissioner's consideration whether you would like me to continue as even a holdover chair.
We need to make any.
Yeah, it would be nice to stay.
I'm making a motion to accept Judge Elizabeth Barrett Anderson as a holdover. Is that the term we're going to use? Holdover.
Chairmanship in my
Chairmanship.
holdover.
To be extended, for whatever duration that may be at the moment. So that is my motion.
I second that motion.
Thank you very much for the motion and the second. Any discussion? All right, there being none, all those in favor of my continuing as chair in my holdover capacity, please signify by saying aye.
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 Thank you very much.
Congratulations.
Thank you very much, commissioners. Amanda, just a matter of comfort. Is the air conditioning not working here? Or is it just my jacket that's making me a bit warm?
It
my
kind
jacket.
of fluctuates.
It's my jacket.
Yes.
Okay. I'm sure.
It's been freezing.
That's true. Okay, all right. So no one else is warm but myself, all right.
I'll take out my jacket to Your Honor, in solidarity.
All right, report, the second matter on the new business is the report of CICC fund level, and we'll have Amanda give us the most current funding.
Yes, Your Honor. So as of April 24, 2023, the CICC fund is at $1,184,487.20.
Okay, that's up about 30,000 from November, because I think November was 1,156,000.
We have received some fees and fines from the court
Awesome.
since then.
No, I just wanted to confirm that's up from the November fund level, correct?
One moment, Your Honor, let me just verify real quick.
Access to.
Correct, Your Honor, it is up
Okay.
from the last hearing.
Up is good.
Yes.
Okay, and what did you say again? That that's a reflection of federal compensation money coming in or?
No, so
Local
this is the
collections.
local collections, Your Honor, from the
Okay.
court.
Okay, very,
Yes.
very good. And that continues to be run smoothly? You don't have any difficulty with financial department at the court?
Not that I know of.
Okay. Item number, any questions, commissioners, on the fund report?
None at this.
Okay. I want to restate that, and I stated this in my confirmation testimony to the legislature, that we have received to date about $289,000 in federal compensation funds. I think it was in 2019, 82,000, 2020, 95,000, and again in 2021, another 82,000. So we are getting, in addition to our local collections from fines from defendants, we are now and have been getting regularly from the federal government. And that comes with a bit of burden, but certainly it also comes with a great appreciation for the work that we're all doing and a recognition by the Office of Victims of Crime that we are a fully operational compensation board. So congratulations to the commissioners here. Item number C is reconsideration of draft legislation amending the CICC statute. What I'd like to do is give commissioners just a brief introduction to item C and then request, and then I will make the motion for reconsideration. In November, Colleen Mike and Dr. Flores, you recall, we went over a draft piece of legislation to consider what I call needed areas for clarification in our statutes, primarily. And we went through about 5 pages of that. Since that time, and in early part of this year in January, we received information from a representative from the Office of Victims of Crime of the concern by OVC, and I'll call it OVC, Office of Victims of Crime, relative to a conflict between the federal grant program and federal crime victim statutes and our local statutes regarding the confidentiality or lack of confidentiality of crime victim records and information here in Guam. After being notified about that, I went ahead and did some research myself, and it was clear that we do have a conflict and we need to resolve that conflict. It's my position until the conflict between the federal confidentiality mandates and our local statute mandates that we not consider compensation awards until this matter is resolved. I think that was received well also by the Office of Victims of Crime. So I knew we had a bill, we had a vehicle, and so I want to return to that vehicle and discuss this afternoon my recommendations to address the issue of confidentiality of victims of crime records and information. I want to clarify that our effort to resolve the conflict will address only the portion of our hearings where we consider the applications and vote on the applications, but it does not refer to administrative portions of our hearing, which will continue to be subject to public hearing requirements, open government, etc. But only the portion where we discuss victim applications, victim statements, victim information, victim medical records, etc., it will be addressed in this bill to protect confidentiality of victim information there. And with that, I make the motion for us to reconsider the draft legislation that was approved on November 18th, 2022, in order for us to address the conflict between federal and local statutes on protecting the confidentiality of victim records and information. Is there a second?
Second.
Thank you very much, Dr. Flores.
I do have a question. How does that affect the statute of limitations in regards to applications moving forward and timeframe with us, I guess, hearing out the case and making it?
It does not. The statute of limitations is a pre-qualification to apply.
Okay.
So you need to apply within 18 months, but once you get in the door,
System, you're.
yeah, when you're in the
Okay.
system, you're in the door, you're okay. Is there any consideration that you want to address shortening or extending the statute of limitations?
At the moment, no, I'm
Okay,
just
all right.
getting a clarification on, this draft bill has the potential, I don't know, to take a few more months versus more than that, so.
It has the potential of taking maybe up to June, July, possibly even August. It really depends on all our efforts as commissioners once we have a product and getting it through.
Who's the head of the?
It's a very good question. We are under the oversight chairman of the Office of the Attorney General, which is Speaker Therese Terlahi. And I don't have all the members of her committee, but it would be appropriate that we submit the bill to her and keep monitoring how soon the bill will have a bill number, how soon it will have a public hearing. There are many things we can do to encourage our favorite senator to move this legislation on. And I hope it moves quickly because of my position, and I hope you agree with me, that we have to delay hearing applications. I know every commission member here wants to get to those applications. But I think because we've been put on notice by the Office of Victims of Crime that we need to deal with this first.
Thank you.
What I'm going to do first for all of you is, did I pass something like this out? No, I didn't.
I didn't think that's normally vote. I just seconded it and then I had a question.
Oh, I'm sorry. Thank you very much, Dr. Flores. We have I moved to reconsider. Dr. Flores seconded that motion. And all those in favor signify by saying aye. Aye.
Aye.
Aye.
Okay, thank you very much. Thank you for that clarification. I'm going to ask you to go ahead. I'm so sorry, Amanda, before we started, I was quite busy discussing matters with Attorney General. I forgot to ask you to make copies of those. The commissioners who are on the Zoom, don't worry about it because I'm going to be reading it. And Amanda, I actually have an earlier copy. Go right ahead and I will start reading. What I'm going to share with you right now are the federal statutes that address this issue of crime victim confidentiality that we need to address today.
Is that the copy that she's gonna make, or is there something similar? Both are federal guidelines.
We have that in the agenda.
It's like the second or third tab to the end. But mine. It talks about some confidentiality.
That's it, what I have and what Amanda is trying to reproduce right now is just a short condensed version of the federal statutes. And I think it's important for me to read on the record specifically what those statutes require. So we can just give a few short minutes for Amanda to copy those. Commissioners, did you have any questions regarding my open statement about crime victim information and records. Did this concern any of you previously, just when we
I'll be honest,
started?
I don't think I ever thought about it. I think part of it, whoever's here, they're all in the same situation, but I don't think in general we went to great detail in discussing their injury, but it is still their information. I guess I assumed, you should never assume. But once you put in your application, the idea is people would be discussing it. When you have the open government, I guess, and that's the second question, because then that's information that's privy to any person walking in that really has no business knowing any kind of information. I think the fact that the binders have always been kept, because there's a lot of information, have always been kept with, the AG's office. It's not something we're able to take home. I just, in my head, felt that was sufficient, but I completely understand and.
There are two things that heightened the distribution and disclosure of crime victim records and information. One certainly is the YouTube requirement under government statute now. And the other is an older provision in our enabling statute. It must go back at least 10 years, that required a twice yearly, correct, Amanda? Twice yearly reporting to the legislature.
Semi-annual.
Semi, so you were, the office was doing it in January and in June.
Correct.
And we were required to put quite a bit of information regarding victim's name, contact, what they applied for, etc. The staff recognized the issue of confidentiality even earlier than we did and would not put the full gambit of information in there. And we were putting, for example, if it's Elizabeth Barrett Anderson, I was application CICC 1-2-3 or whatever. And so that was, and then my information would go over and be reported to the legislature biannually. And even that was triggered. That triggered a review by the OBC. And one of the reasons why perhaps we have not been, or it hasn't been discussed with Guam previously, is that we just began receiving federal compensation money under the Victim of Crimes Act. Before that, we weren't getting directly compensation money into our fund. We had some members of the staff or the Attorney General staff who were paid partially from VOCA money. But once the compensation started to come to the territory, then it was incumbent upon us to make sure that we were compliant with federal guidelines. And I think we're on the right road, and I'm glad it's been brought to our attention sooner than later. And I don't think, I think we tried to do everything we possibly could to keep confidentiality. And the statute, and we have in the past previously closed a couple of hearings where we had an applicant in a sexual assault case, and we asked, would they like us to, the statute allows us to clear people from the public hearing room. But that doesn't solve the issue of the reporting to the Guam legislature and the social media aspect of open government currently. What I'd like to, and bear with me, commissioners, please bear with me as I read this. The Victims of Crime Act, Title 28, Code of Federal Register, Chapter 1 of the Department of Justice, Subpart B, Section 94.115, which is non-disclosure of confidential and private information. It states, confidentiality. an SSA, and I believe that refers to sub-grantees, and we are a sub-grantee state. I can't remember what SSA, but we are an SSA.
Sorry, Your Honor, so SAA?
SAA.
Yes.
Yeah, SAA, the Attorney General's Office, and we are a sub-recipient, a sub-grantee. VOCA funds shall, to the extent permitted by law, reasonably protect the confidentiality and privacy of persons receiving services under this program, and shall not disclose, reveal, release, except pursuant to paragraphs B and C in this subsection. 1, any personally identifying information or individual information collected in connection with VOCA funded services requested, utilized, or denied, regardless of whether such information has been coded, encrypted, cached, or otherwise protected. And so that's what I was talking about, commissioners, when we would report semi-annually to the legislature, we were encoding, encrypting, and otherwise protecting, and that is prohibited. 2, individual client information. Without information, written, reasonably limited, time-limited consent. Hold on just a second. Let me just write that down. Or individual client information without the informed, written, reasonable, time-limited consent of the person about whom the information is sought, except that consent for release may be given by the abuser of a may not be given by the abuser of a minor, incapacitated person, or the abuser of the other parent or of the minor. If a minor person or a person with a legally appointed guardian is permitted by law to receive services without a parent or guardian's consent, the minor or person with a guardian may consent to release of information without additional consent from a parent or a guardian. And basically it's saying, do not release the information without the written consent of the victim, and in our situation, an eligible applicant as well. So that's VOCA. The next act is the Violence Against Women Act under Title 42 of the United States Code, Section 13925. B2 states, in order to ensure the safety of adult, youth, and child victims of domestic violence, dating violence, sexual assault, or stalking, and their families, grantees and sub-grantees under this chapter shall protect the confidentiality and privacy of persons receiving services. Grantees and sub-grantees shall not disclose, reveal, or release any personal identifying information or individual information collected in connection with services requested, utilized, or denied through grantees or sub-grantees programs, regardless of whether the information has been encoded, encrypted, hashed, or otherwise protected. Again, same language. Or disclose, reveal, or release individual client information without the informed, written, reasonable time-limited consent of the person. And it goes in again to what I described about minors and guardians. VAWA confidentiality provisions require all grantees and sub-grantees receiving VAWA funding. I'm not sure if we receive VAWA funding, do we? I know we're VOCA.
I'm not sure about that, Your Honor.
Okay, but it's good to know.
VOCA, yes.
Well, maybe we might receive VAWA money in the future. From the Department of Justice Office on Violence Against Women. I know the territory does receive VAWA money, some of our other grant programs on Guam. Receiving them funding to protect, must protect the confidentiality and privacy of persons to whom those grantees and sub-grantees are providing services. The VAWA confidentiality provision is designed to ensure the safety of adult, youth, and child victims of domestic violence, dating violence, sexual assault, and stalking. I'll go down to the next act is the Family Violence Prevention and Services Act under Title 42 of the United States Code 10406 C, subsection C5B, non-disclosure. The Violence Against Women Act and the Family Violence Protection Services Act both provide grants to states to fund services for crime victims and require the organizations that receive funding to keep victim information confidential as a condition of funding. Under the Family Violence Prevention and Services Act, grantees and sub-grantees shall not disclose any personally identifying information collected in connection with services requested, including services utilized or denied through grantees and sub-grantee programs, or reveal personally identifying information without informed, written, reasonable, time-limited consent by the person about whom information is sought, whether for this program or any other federal or state grant. So you can see the commonality among all three.
Seems pretty clear.
We should have known it was clear.
Except when we go to open government. And it's like a whole different scenario.
And Dr. Flores, please do me a favor. Remind me of what we just chatted about in a few seconds about why didn't we know and we should know. So please, let's get back to that. Remind me if I forget before the end of this meeting. There are several open government statutes and commissioners. I have to let you know that my basic constitution is full support of open government. As a senator who had the open government law passed, and then as a judge who on many occasions was requested to close hearings even in court, and I believe in open government in my bones. Mm-hmm. However, I believe that this is a new generation and we must focus on protecting crime victims, and that makes it a little bit different. The open government law on Guam is the statute that requires broadcasting is contained in 5 GCA section 8103D, which states, except for executive sessions and other meetings expressly authorized by law to be closed, and please remember that, to be closed, regular and special meetings of a public agency shall be broadcast via live video streaming applications as announced in the notice of meeting and on the agency's website. The open government law also states under section 8111D that under no circumstances shall a public agency vote on any matter before it during an executive or closed meeting. All voting must be held in a public meeting and minutes shall be kept and open to the public. The reporting requirements are under section 8113.1, requirement of boards and commissions. And this requires that boards and commissions shall provide electronic copies of the monthly board and commission meeting agendas, approved minutes, and other attachments and addendums as discussed in each monthly meeting to the legislature and to the governor, no later than 15 days after the end of said meeting, et cetera, as well as providing a copy within 7 days to the Office of Public Accountability. And lastly, in addition to open government, there are FOIA requirements for government documents. And those FOIA requirements, which are freedom of information, allow the public to request inspection of public documents and in certain situations to copy those documents. There are limitations under the Freedom of Information Act, and the exceptions to document inspection and copying are under 10108C, Those are personnel, medical, or similar files, the disclosure of which would constitute an unwarranted invasion of personal privacy. And then under I, all existing privileges or confidential records, and that's the key, or other information expressly protected under law shall not be abrogated by this act. And under law, in my perspective, would be our federal law requirements. All right, so how do we accomplish this and still meet our obligation as a commission to open government and public participation, while at the same time to protect crime victim confidentiality and information? My recommendation is, again, I'll repeat this, is that the commission is held to public meetings, and we will continue to do that. I will now get to how do we accomplish confidentiality. All right, if you could turn to in your binders, the draft bill up for our consideration here. And on page 1 of the draft bill, what has been added would be starting at line 8 to line 10, where we provide the legislature information about the Violence Against Women Act. That's the information I have just for the last 10 minutes read. The federal statute regarding confidentiality under the Violence Against Women, VAWA, the Family Violence Prevention and Services Act, as well as the Crime Victims Act, VOCA. And those are the federal statutes that we are dealing with. So that is added, that would be added, and I'd like to ask, is there approval in adding lines 8 and 10 to our prior draft of our draft legislation? Do I have a motion on that or any questions?
So moved. Motion.
Oh, thank you. Seconded, please.
Second.
There's been a seconded. Are there any objections? There are no objections. All right, thank you very much. Going to page 2. What is being added to our prior draft of November starts at line 16 to line 20. This did not exist in our definitions previously. We are now in the CICC enabling statutes, which is Title 8 of the Guam Code Annotated at Chapter 161. 161.10 are the definitions, and I would like to add definition of confidential record under C. And it would read, confidential records means the name, contact information, medical records, statement of personal experiences resulting from a crime. We should put statement and communications of personal experiences. It's a possibility, including compensable injuries or damages suffered, or any information of a victim or eligible applicant, the disclosure of which would constitute an unwarranted invasion of personal privacy or a violation of local or federal law. The commissioners, just take a few moments, and I am open to a motion, and then we can discuss whether we like this particular definition or we would like to change it in a time. Can I have a motion, please?
I make a motion to accept it. I do want to add, I guess, a comment.
Let me get a seconded. Let me get a second, and then I'll take your discussion on it. Do I have a second?
Second.
Okay, thank you, Colleen. Mike. All right, Dr. Flores, your comments about the definition.
Just to clarify on what disclosure means. It's just I can read into that in different ways. I mean, certainly in disclosing the information that they have amongst the commissioners and those involved with making, I guess, a judgment or a decision or vote would not be, formally then included in that disclosure, but if I'm reading it, I guess the question would be, who then is able to view that? What does disclosure to who mean?
I
I don't
think,
know if it's
I think it,
understood or.
I think as we get to the other provisions on disclosure limitations, maybe this will be more understandable. Do you want to defer on this? We can come back to it.
No problem.
Okay,
Just,
all right.
You know, if I'm just blanket reading that, I feel like I could interpret that in different ways and
Of course.
just wanted
of
to get
course.
clarification.
So, commissioners, why don't we defer on this motion on item on page 2 of 16110, the addition of a C, definition of confidential records, and come back to that. And Amanda and Dr. Flores, please remind me to come back to that, okay?
We'll do your honors.
Okay. Page 3, there have been no changes from our November discussions. However, I will make mention that just before we started our meeting, the Attorney General had asked a question whether brothers and sisters would be eligible as applicants. And I indicated not under the current statute. If you look at lines 6 and 7 on page 3, we deleted the definition of a relative. And the reason for that is because the term relative was basically not used at all in the statute except to define a dependent. And it's terrible to have, you know, well, anyway, it's not great legislative drafting, but if you look at that relative, we did have an expanded group of grandparent, stepfather, stepmother, grandchild, brother, sister, half brother, half sister, and even the spouse's parents. Should we consider an expansion of that, or is this something that we want to leave it narrow because of the limitation of our fund, which is not very large? It sounds like it's large, but when crime victims come in and they have medical expenses, that money doesn't go a long way.
My initial thoughts, Madam Chair, is that we continue to keep it narrow for such time until perhaps we commission later on. But I think for now, considering the limitation of our funding, it's okay. We have an endless barrel of stuff, but we don't. And considering Guam is very small, anyone could be a possible brother or sister or any relative of that, considering how do we define it. So I tend to be a bit conservative at this point.
Commissioner Denise, I know, Commissioner Mendiola, I know you weren't here. We were even talking about how far this could go because of our culture in Hokusai. You know, you raise a child who is not your natural born child. It's not, that child is not adopted, but is your brother or sister's child, and you raise that. And so the whole concept it can be quite broad and expansive. I'm more in favor of expanding it, but perhaps maybe now is not the appropriate time. Anything?
It's a struggle. I
It's a
think
struggle.
again, when we come up against cases and we do have some applicant that is coming on behalf of the victim who may have even passed, and there's nobody else, and they're the ones that foot the bill, and they can't get any compensation otherwise. It's not perfect, and I at the moment I would agree with Commissioner Polly White that unless we have an excess amount, sure, we can certainly consider it. I'm already looking at the spouse, and I'm assuming this doesn't include common law, if I'm reading
No, it
it
doesn't.
as it is, and that's a whole other scenario to look at. It's a struggle. I'm
It is a
kind of
struggle.
on both sides, and but we have to do what we need to do with what we can.
Denise, any comments you want to make?
No, I'm just thinking as you're talking, in the past cases that we've had to deal with, and it was primarily those 3 siblings that were trying to get some compensation for the death of their brother. And I think that the issue is that they weren't aware, of the rules, right? So I'm wondering if in the front end that information may be provided to applicants when they're going to apply for compensation, so that they come at this with the understanding of what they could qualify for. And to keep, I agree that we should keep it narrow right now, just because it would be nice to see what the other jurisdictions are doing or how they're dealing with this.
All right. I indicated to the Attorney General I would bring that matter up, and I don't seem to have a motion at the present time to change that. Just to reiterate what Dr. Flores was talking about, with regard to spouse, we are adding the definition of spouse in this matter. It's line 9 and 10 of page 3. And the reason why spouse is important, and it will come at the next section. Spouse in our draft legislation would be, it means a person, male or female, that's or, not of, or female, who is legally married to another person, male or female, and provided no dissolution proceedings are pending. So this would not incorporate common law. Just to clarify for the commissioners, common law marriage does not exist on Guam. We have common law recognition of relationships in order to legitimize the children, but it does not legitimize any relationship between the male and the female for legal purposes. I don't know if you knew that, Dr. Forrest, or anyone knew that.
But it does, it's like insurance. It seems to.
If an insurance company wants to open it up, that's their privilege, and they may do so. But by law on Guam, we do not recognize common law marriage at all. There is absolutely no recognition of the relationship as married people between a man and a woman here on Guam, and it maybe comes to in the future of males and same-sex gender relationships. Common law marriage does not exist on Guam. So H would not expand it. Okay. But it would allow same-sex relationships that are legally married. Do I have a motion to adopt the definition of spouse on page 3 at line 9 and 10? Do I have a motion on that one?
I make a motion subject to correction.
Okay, can I have a second on that, please?
I second the motion.
Second. Thank you, Polly Mike. Any further discussions on the definition of spouse? There being none, are there any objections to the definition, to adding this definition to our draft bill? There being no objections, the definition of spouse is added to the bill. We turn to page 4, and this is where the definition of spouse becomes significant. Page 4 at line 6. We have, in the case of the death of a victim, these are the words to be added, to a spouse. Our previous statute did not recognize the spouse unless the spouse was defined as a relative. It did not do so in subsection 4. So we deleted the definition of relative, and I think it's now important to put the term spouse in number 4. If we go back to page 3 for a second, section 161.50 of our statute talks about eligibility for compensation. Number 1 is the victim. Victim is eligible for compensation. Number 2, any person who's responsible for the maintenance of a victim or has incurred pecuniary loss because of the victim's injury. So someone who takes care of the victim, someone who's taking care of the victim. That could presumably be a spouse, it could be anybody. Number 3 are dependents of the victim who has deceased. So the victim dies, whoever was a dependent of the victim. And under the term dependent, a dependent is persons who were wholly or partially dependent upon the victim's income at the time of the victim's death or injury, and includes a child of the victim born after the victim's injury or death. That's pretty broad. So any dependent, it could be a stepchild, it could be a proxy, anyone who's a dependent. It could be a grandparent who's dependent upon the victim prior to the victim dying. Number 4, that's where I want to put spouse in. Number 4, in the case of the death of the victim to a spouse, to a parent of an adult deceased victim, to an adult son or daughter of a deceased victim, where the, I think we need to put spouse, where the spouse, parent, or adult son or daughter has incurred expenses on account of hospital, medical, funeral, burial expenses as a result of the victim's injury and death. So 3 and 4 reference the victim dying and who are eligible applicants upon the death of a victim. More often than not, we get number 4. Not more often than not, but in the case of the death, we have number 4, a spouse, an adult son or daughter. Now, mind you, the victim has to be an adult. If the victim is a minor, then it's going to be the parent filing. So right now it's the spouse, parent, adult son or daughter for hospital, medical, funeral, burial expenses, etc. Here, we do not expand it to brothers, sisters, uncles, etc.
The exception would be in, I guess, line 1 of that page. If somebody, whatever that person may be to the victim, if that person had been responsible for, again, caring for whatever the situation may be, that particular person could claim as long
Yes.
as they were caring for the victim even prior to an injury.
Correct. Because in number 2, it's a caregiver, it says any person who's the caregiver and takes care of that injured victim who's perhaps disabled and severely injured and is recovering from injuries. Absolutely, number 2. And it doesn't have to be a lineal descendant. Anybody.
But if, let's say, again, I guess I'm just envisioning someone, the victim, an adult in this particular instance, maybe mentally handicapped, and a sibling has been taking care of them. The victim ended up getting an injury, dying, and the sibling who has been caring for that victim prior to the injury, then could apply and be compensated accordingly.
Because that person is responsible for the maintenance of the victim.
Prior to.
Absolutely. Yeah. Okay, very good. So the only thing we are changing in section 161.50, which is the eligibility, is to add the term spouse. Make it clear. Did we have a motion on that yet? Not yet, right? For spouse, in the case of the death of the victim to a spouse, and then add spouse on the on line 7. Can I have a motion on that, please?
We did not have a motion.
No, all right. So on motion for page 4 to add those words between line 6 and line 9 of the bill. Can I have a motion, please?
I make a motion.
Okay, may I have a second?
Second.
Okay, thank you, Polly Mike. Any further discussions? Commissioner Mendiola, Polly Mike, any questions?
Not for me.
Not for me.
Are there any objections? If none, the motion passes. There are no changes to page 5 of the original bill as approved. There are no changes to page 6 of the bill as originally approved in November. Page 7, and this is the first recommendation to address confidentiality of victim records and victim information. You will find it starting at line 17 to line 23, and it carries over into the next page. It's an amendment to existing statute 161.130. And this has been the semi-annual report that Amanda says is filed every January and June. So what we're addressing first off is the reporting requirements. And this is a section of our enabling law that has been there for 10, 15 years. So it's not something new with regard to social media. It was just put there a long time ago. And I think it was placed in our statute because the legislature wanted to monitor whether or not the commission was functional. Did we have commissioners? What's happening? So the legislature always likes reports. And they were very much interested in the commission becoming functional. And so they wanted the Attorney General every 6 months report, is the commission functioning? Well, we finally became functional in 2016, and now Amanda's been filing every January and every June. But this also addresses the type of information that the legislature had requested. And if you look at line 19, which is scored out, the name of each applicant, a brief description of the facts of each case, and the amount of any of compensation awarded. So that is where we have struggled. And no amount of encrypting of the applicant will work according to the federal statutes. My requested amendment to the statute would read as follows. It is now an annual report. The Attorney General shall, and go down to line 22. From line 18 to 21 is deleted, and half of line 22. This is the addition. On behalf of the commission, include in the Office of the Attorney General's annual fiscal year budget submission to the legislature, a report on vacant appointments to the commission, the total number of applications received for the prior year, the total number of awards made in the prior calendar year, current balances in the CICC fund, and any specific requests for appropriations to the Office of the Attorney General for administrative support of this chapter, which means the CICC. So the reporting will be made by the Attorney General during the budget year. And it will be aggregates as we have done in the past. We've had over 280 some applications. We've awarded over $870,000 in awards in the years that we've been functional. I mean, that type of information I think is appropriate to the legislature. I don't see the problem reporting that, but it should be done at the budget time because that's where it makes more sense. Do I have a motion to approve the amendments to section 161.130 of our enabling statute as I have read on page 7 and page 8. Do I have a motion, please?
I make a motion.
Okay, thank you. Do I have a second, please?
Second.
Okay, thank you. Any further questions or discussion on this reporting requirement of our statute? What I like about this, commissioners, is we can ask the Attorney General in the appropriations request to the legislature of the Office of the Attorney General for some money for the commission. And I did, Denise was there during my confirmation hearing, and I boldly stated to the senators who were there that the commission would like some money for personnel, for Program Coordinator 3, for travel, so we can get training and we don't have problems like this, so the commissioner can attend the boards, the National Compensation Board's meeting that is conducted every summertime in Washington, D.C., along with the VOCA grant state grantees. They all converge in an annual meeting and to get training so that we are kept up to date on these matters. So putting it in the budget to me gives us an opportunity to have a meeting where we say, this is what we'd like. And I did ask also for some money for supplies and materials, I think. Okay.
Thank you.
If there's no further discussions, all those, rather than saying in the negative, all those in favor of the adoption of the amendments to section 161.30, please signify by saying aye.
Aye.
Okay, thank you.
Aye.
Aye.
The next recommended addition to our bill to address victim confidentiality starts on line 14.
So what did you?
We are still on page 8, and it's line 14. And I'm going to give Denise, here's a copy. Yeah, this is. Commissioners, let me read. You have in front of you line 14B, which is an amendment to section 161.30 of our enabling statute. At line 14, it's subsection B. Do you have that there? What you have in front of you starts out with the commission is authorized. I would like to make a change to that, and this would be the recommended language. It'll start out by saying all hearings. And this is our, sorry, I'm going to go back to 161.30 is our statute on hearings and evidence. So B would start out by saying all hearings shall be open to the public, except the commission is authorized to conduct closed meetings to consider and vote on crime victim compensations. And that would address the concerns with open government. If you recall, I read that section of our open government law, which reads, except for executive sessions and other meetings expressly authorized by law to be closed. Regular and special meetings of a public agency shall be broadcast and noticed in the website. So we'd be asking the legislature to allow us to close those portions of our hearings to consider and vote on crime victim compensation. Why don't we, also it would, at line 17, delete line 17 to line 20 of subparagraph B. So this is to close and to vote during, to close the hearing and to vote on compensation.
So this would override the, what is it, the 5 CGA 811, under no circumstances shall a public agency vote on
Yes.
any matter.
Yes. It would address section 8103D and 8111D.
Okay.
Would you like me to go into the next one and then come back to this?
No need to come back to this unless there's
Okay.
any other question.
Do I have a motion and we can have some further discussions on this? A motion to approve the amendments to section 161.30B as contained on page 8 of our draft bill and as substituted by what I have just passed out and read on the record.
Make a motion.
Thank you. It's moved. Second, please.
Second.
Okay, thank you, Polly Mike. It's a very simple one sentence, but it's a very significant one sentence. Okay. The last amendment to our enabling statute will be to the same section, which is 161.30, addressing our hearings and evidence. And it is to add a subsection E. You can find that on page 9, starting at line 8 through 10. And this defines confidential records, or not defines it, I'm sorry, it uses our definition of confidential records. So we could now go back to the definition of confidential record. I think that's on page 2. Page 2? Yeah. Okay, so we need to go back to that, but this is why I think, Commissioner Flores, it was good for us to maybe defer on that until we got to where that definition made some sense. Line 8, a new subsection E is added, reading confidential records of a crime victim. Hold on, let me see. Okay, confidential records of a crime victim or eligible applicant are not subject to disclosure, inspection, publication, broadcasting, or reporting to any government or law enforcement entity without the prior written consent of the victim or eligible applicant. And in the federal statutes, over and over again, VOCA, VAWA, and the Family Violence Prevention Act, Prevention Services Act, talked about reasonable, time-limited opportunity for the victim to make a determination of whether they wanted to allow their information to be made public. So the premise is it's confidential and not made public, but the victim can allow that to be open with written consent and timely and reasonably proffered to the victim during their application process. So do you see how the two coincide. Dr. Flores, if we could get to your question of disclosure now. And maybe you can expound a little bit more on disclosure. Disclosure would be outside of the commission and our hearings.
Then as long as that is understood.
Okay. Do I have a motion then?
Okay.
Okay, it is moved to add subsection E to section 161:30 of our enabling statute. Do I have a second on that?
Second.
Second on it. Any further discussion on this matter? One thing that we would have to do in working with our staff is to develop a specific written consent form, which is not currently available regarding confidential records. Amanda, right now, we do have a consent form that victims are allowed to sign and waive their right to a privilege. Guam has a privilege, and privilege is different from confidentiality. Privilege is doctor-client privilege. So when I was Attorney General, we created a privilege on Guam, which is victim advocate privilege, like a doctor-client privilege. And when an applicant comes in, the applicant, victim is asked, would you waive your confidential information in order for the advocate to assist the prosecutor in the development of the prosecutorial case? Is that what we currently have, Brian Amanda? Is a waiver of the privilege?
Are you referring to the victim advocate privilege form?
Yes, yes.
Yes, we still have that.
Yeah, okay. So that's different. That's totally different from what we're referring to here. That's waiving a privilege. This is waiving the dissemination of the information which is federally protected because of the federal statutes, and now soon to be our local statutes as well. So we'd have to develop a written consent form reasonably offered to the victim in a timely manner, whether or not they have, they allow us to, and that would be up front. It's not something down at the tail end, I think, something up front we want to ask the victim. I think more likely than not, the victim, most victims would say, I don't want my information to be disclosed, open to the public in any manner. So, but we'll develop that kind of a consent form, and then we can review it here at the commission again, at one of our administrative hearings. Okay. And is there any other discussion?
No, I think this is awesome. You're tying all these loose ends and getting things moving forward.
Okay, one last consideration, but do I have any objections to the amendment to 161:30 of our enabling statute to add section E? I think we did make a motion already. It's just discussion, right, Amanda?
There was a first and there was a second. There just needs to be a vote.
Okay, so all those in favor signify by saying aye.
Aye.
Why you keeping track?
Aye.
It's easy. How about me? I've got to go through each of these. And commissioners, the very last one on page 9, it starts at line 21 and 22. This is not to our enabling statute, but it is to Title 8 of the Guam Code annotated section 70.20, which is the discovery requirements in criminal prosecution. A defendant's attorney, a defendant and defense counsel are entitled to information, discovery, evidence in the possession of the prosecutor, which is the Office of the Attorney General. And the prosecutor can be ordered and has a mandate under law to turn all information over to defense. There's no surprises here. It's not like television. They know what's coming down the pike. Because the office of because the Criminal Injuries Compensation Commission is within the office of the Attorney General, my concern would be that under the discovery mandate of a criminal trial, we would have to give confidential information of our victim and whatever's contained in our applications to the prosecutor. Because we are within the realm and the purview of the office of the Attorney General. And the statute doesn't say, well, Attorney General, but if it's over in this division or over in that division, no. If it's within the office of the Attorney General and that prosecutor can reasonably locate and request the information, whether it's in a different division, it could be argued that we'd have to turn it over as a commission. And I am recommending to add to this section, which is 70.20, which states matters that are not subject to discovery by defendant, notwithstanding sections 70.10 and 70.15, the prosecuting attorney shall not be required to disclose, and I'm adding C, confidential records, and we have a definition of confidential records, under the program jurisdiction of the Criminal Injuries Compensation Commission. So that's the last addition. Can I have a motion on this, a second, and we can discuss it if discussion is needed. Motion, please.
I make motion.
Motion to add that. Can I have a second from Commissioner
Second.
Mendiola or? Thank you very much. Okay, it's been seconded. Is there any further discussion on this matter? Okay, there being none. All those in favor signify by saying aye.
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 Okay, and it passes.
Your Honor, I do want to note for the record,
You have
you
to go
need to
back.
go back to page 2.
Confidential.
Correct.
Okay. I believe there was a motion to add C to the definitions in our prior draft of last November. We delayed on that, and it was seconded as well?
If we can just go ahead and get another one.
All right, let's do that over again. Can I have a motion to adopt the definition of confidential records as contained on page 2, lines 16 through 20?
So moved.
Second.
Okay, moved in second, moved by Commissioner Mendiola. Any further discussion? There being none. All those in favor signify by saying aye.
Aye.
Okay. Thank you. Wow. Not easy, is it? Okay. With that, commissioners, a final clean draft of this will be prepared. And would you like me to have Amanda send it to everybody as a clean draft? Just one last time, so it comports with your recollection of what we have done here today.
Yes, please.
Thank you. Go back then to the agenda. Let me give you an idea before we get to item D on the agenda. Is once we have a clean draft and the commissioners have had an opportunity to review the clean draft, I will prepare a letter to the chairwoman of the committee, which is the speaker of the legislature. Would you all like to sign it by perhaps a resolution or sign it by letter? Do you want to sign it?
Sure.
Okay.
Whatever you feel is.
Okay, well, I'd love to get your signatures on this.
Sure.
Okay, so I'll prepare a letter, all commissioners can sign. We will send it to our oversight chair, which is the Speaker, Therese Terlahi, and requesting that the matter be placed introduced into a bill form. And hopefully we will get a hearing date as soon as possible. We are going into summer, and I would like to get this passed before the legislature goes into its budget hearings. Because that gets crazy. I can't guarantee that, but I'll ask, perhaps I'll talk to the speaker and see if she can get it on the session floor as soon as possible. Before it ever gets on the session floor, we have to have a public hearing on the bill. I'd like to have all commissioners there present on the bill. This is not an easy bill. And although I can speak loudly to what the amendments we have made, I need all commissioners to also speak as loudly in order for us to preserve the confidentiality of victims' records. I would also suggest that we select our favorite senator, and when the bill is introduced and before or even after public hearing, the way you get something passed is you speak to all the senators, and so by the time it gets to the floor, hopefully there is not much discussion. I will also mention, however, that a bill that's 9 pages, once it gets to the session floor, is subject to all kinds of amendments by the senators. We have no control over that. And that sometimes is good and sometimes it's bad. So as long as they keep our amendments in, then we'll have to deal with whatever amendments that they choose to add to our bill, if any at all, and I hope there's none. But the longer a bill is, the more pages for senators to look at it. All right, we'll go to now the next item on our agenda, which is a funding request for email accounts. Could I ask Amanda to give us an idea of email accounts? You know, the Office of the Attorney General has a .org. Is that the Google account?
So just for the record, there was a Google Workspace created for the CICC last year.
What is a Google Workspace?
Google Workspace is so it has email accounts, and then it's a cloud storage as well. So that's where we keep the files for the CICC.
All the email files, or
Correct.
any attachments?
Correct.
Okay.
Correct. That is correct, Your Honor. And there is a fee to have this Google Workspace, and right now it's at $6 per user per month. So
That's kind of nominal, right?
so it would cover the support email, which is monitored by the staff.
Mhm.
And
That would be
each-
you?
Currently correct, yes. And then also each email account for each commission member. So then that would be a total of 5 email accounts at this time.
I'll tell you, commissioners, it's so much better than using our personal. And it's just a funding issue. Are you aware whether or not the current administration can fund that? Or do we need to make a request to the Attorney General to fund it?
So there was question whether we can utilize the CICC fund to cover the procurement fees. However, to my understanding, we're unable to use that. I believe the money in the CICC fund is only for awards.
Awards, okay, all right.
Yes. And then I guess it would need to be officially approved by CICC. I'm not too sure how.
See, that's why we need to go on these trainings. So we can ask simple questions about how can we get an email funded. I'm going
What
to,
does AG say?
we haven't asked him. So I'm going to instruct Amanda.
Who's our, I guess, is it this Matt gentleman that's the deputy for?
No,
Sure.
Matt Assistant Attorney General Matt Strader, is assigned to assist the commission. But I think for something like this, we should just go directly to the Attorney General. I can write a letter requesting, we don't even have stationery yet. And then send that to Amanda, and Amanda can pass it on to the AG, or what I'd prefer to do, Amanda, I'd like to get the Attorney General's email so I can write directly from the President Commissioner to the Attorney General. And he will see that I'm using my personal email to communicate with him on a CICC matter, which is about getting our own request for an email account. And I think it works so much better to use an official CICC account in communicating on CICC matters. If I were to send something to the Speaker of the Legislature, it's so much better under a CICC account rather than my personal account. So Amanda, my request to you is to ask the Attorney General for permission to give me his email.
Yes, Your Honor.
And Commissioners, I will request the Attorney General to either reactivate under his local budget the email account, and then I will also, in addition, ask him to request the legislature for a nominal appropriation of $5,000 in his budget directed to the CICC for things like this. Amanda, would you know under what category funding for email accounts would be? Is it contract services? Is it supplies and equipment? Is it, do you know the
I believe
categories?
that would fall under contractual.
Gotcha, so that's 230,
230.
okay,
Yes.
230, okay. So we'll do that. I'll request 230 appropriations. Does anyone know how much needs to be used under current OAG budget or requested for next year for a CICC email?
Okay, so if we're looking at $6 per user, so that's 6 times 5 users. So $30 per month times 12, so that's $360 a year. $360 a year.
Okay, just give me the email for the AG. All right, Commissioners Mendiola or Holly Mike, any comments on getting our CICC email back in operation?
I concur, Madam Chair. I think we do need that for official business and not our personal email.
Yeah, Polly Mike, we still need stationery, right? Should I add in maybe $500 for some printed stationery with our logo?
Yes, yes, I think you should. Let's go
Okay.
for the moon. Ask for the moon.
Oh, I like the moon, there it is. Okay, all right.
My only request, which I've appreciated in the past, is just to notify us, WhatsApp or whatever the case, that emails are getting sent. I'll be honest, I have several emails to follow. And so I may not necessarily check the CICC emails on a regular basis.
Yeah. That's a good point. I was mentioning that also to Amanda. If you text us, please check your email. And now it's currently our personal email, but hopefully our CICC email. Okay. Well, I look forward to that getting up and going. I really, really do. The next item on subsection 5, new business, is E. The NAVAA 2023 VOCA National Joint Training Conference. And that's under tab E.
Tab 2023 Boca Conference.
Okay. Save the date. On August 14th to the 17th in Chicago, Illinois right now. Hot summer in Chicago. The Office of Victims of Crime will be sponsoring a joint training. And this is their annual training, I believe. Is that correct, Amanda?
I believe so.
Yeah.
It's usually around this time.
Yes.
That date of
More often than not, it's in Washington, DC. but this one is outside of DC, it's in Chicago. And it's the National Joint Training Conference for VOCA Victim Assistance and Victim Compensation Administrators. And this is the conference that I attended when I first became Attorney General, and I became aware that there's an organization of victim compensation administrators and boards. And I went, oh my goodness. So there's a vast amount of information that you can gather just by being at these conferences to develop relationships with other boards and commissioners in other states and asking them dumb questions, which I really love dumb questions because I have a dumb question. I know that a lot of other people have the same dumb question, but they're just too afraid to ask. There is no such thing as a dumb question. They're great questions. So I believe that we should send a commissioner off island. If anyone is going to be near Chicago at that time, please let us know. I believe the travel should be given to those who have been here longer than me. I don't like to travel. There is someone here who was very good at traveling. However, Guam as a territory needs to make a presence as a commission, a compensation commission, and make alliances, make friendships, and learn a lot from these trainings as well as what other states and commissions do. Now, we don't have any money for this. Do you want me to add this to my request to the Attorney General?
Yes.
Yes, Your Honor. I think there should be some funding for this. I think it should be under VAWA or VOCA, but I think under the AG's office, I hope that they'll be able to look at it, their grant funding, and see if that's possible. I know it's possible if it's just available.
Okay. I do recall during my tenure as Attorney General, the VOCA grant to the Office of the Attorney General does have funding for travel. I have gone as Attorney General, and my Chief of Staff went with me. She was a grant genius, grant expert genius, and she knew a lot about the relationship with VOCA and the federal grant programs. I asked Attorney General Moylan if he was going to go this summer. We were Polly Mike and I met with him. Oh, by the way, the meeting went very well. Polly Mike and I met with him in March, and he was very supportive of all that we're doing here. But I asked him, I said, are you going to the VOCA training? And he said, no, not this year. He's been previously, and he has too much on his plate, so he wasn't going to go. So I would like to, in that letter I sent to him via the email that Amanda is going to give me, that we ask if we can use the VOCA travel this year to send someone who is going to be, who likes to travel and has been here a long time and doesn't mind going to Chicago. Polly, Mike, or Denise, what are your thoughts on, would either of you be interested in going?
I would probably be on a conference around that time with the National Sexual Assault Conference, NSAC, which is in San Francisco, I believe the week after this VOCA conference. So if I were to go, it'd be a back-to-back conference.
If you go, would you be able to use the funding that you were going for the San Francisco conference, and then perhaps either Amanda or another commissioner could go?
I could probably, we could probably look at that, see if our funding can support maybe just the trip from San Francisco to Chicago. And that way the other funding can take care of from Guam to San Francisco. So that the only thing will be the conference fee and hotel, things like that.
Okay. Well, let me work with Amanda on those costs. possibly from San Francisco down up to Chicago. That's how.
And maybe we can check with the coalition. They also have funding. And maybe hopefully with Cynthia, she can see if that can be supported by their grants. I do know, I did hear, I'm not confirming this, but I know the Governor's Community Outreach Federal Programs Office had given money to the AG's office, the stop funding, but I think some of those were returned from the AG's office. So I'm not sure how that will affect it, if that's some funding that we could use.
Okay.
But I'm not sure if Amanda is aware of all of that.
All right, let me, in the letter to the Attorney General, request that a commissioner be permitted to use VOCA funding to attend the Chicago conference.
Maybe you want to include 2 commissioners, and that way he'll say, oh, okay, we can't afford 2, but we'll do 1. Shoot for the moon, Your Honor.
Like the way you negotiate. Okay, we will ask for 2 commissioners. That's okay. Amanda, at some point in time, as the commission continues to be stabilized with its personnel, I think it's appropriate that you also maybe the next time go for training with the commissioners. I also want to encourage the commissioners and for Amanda to look at their, VOCA has a lot of online training. If you go to VOCA, Google VOCA, there are webinars, left and right webinars, and webinars that have occurred over the last 2, 3, 4 years that you could go back to the webinar. And it's good for us to take time to open those up. But we are so far away. The travel is very, very difficult. But I hope our desire to come and receive training, because if we had had the type of training that is essential, then perhaps we would not have to have a current delay in listening to applications in order to take care of the conflict between the federal and local statute on confidentiality of victims' information. Nonetheless, go ahead. Did you want to say something? Okay. So I think training is absolutely essential. Don't hesitate. I've actually sent some material to the commissioners. There was a primer. I sent one the other day, a primer on, what was that? Yeah, a primer. Everything you ever wanted to know about victim privacy was right in that primer. A lot of what I read is in that primer. So there's a lot of material, both webinars, actual training and conferences, and I'm sure brochures at the VOCA office that we need to start educating ourselves on. All right, Polly, Mike, I think you said ask for 2 and see what we get, right?
Yes, Your Honor. Another idea, thought, if the commission wanted to apply for grants, do we go through the AG's office, or will we be able to apply directly to, let's say, VAWA? Are we under the AG's? I mean, I'm assuming we're under the AG's office. We keep using their.
The commission is under the Attorney General's office because the legislature
Right.
wanted us to incubate somewhere.
Right.
Could the commission be independent? Yes. It would take a budget that would allow us to have a nominal amount of staff, rental, power. I mean, the whole budgetary requirements for a commission to be independently functional from the Attorney General's office.
Mhm.
That may be a situation down the line as the commission continues to sustain itself and to be recognized by the legislature, not as just a dysfunctional commission, but an actually forming commission that is operational, with commissioners who have been on this commission for 15, 20 years. Does that answer your question? We could be independent, but we'd have to
Yeah.
have a full operational budget
Understood, yes,
and an executive director.
correct. And I think we also can, I think there are some grants that may have that for discretionary or administrative purposes. And we'll be able to utilize that ultimately, but we'll get more educated on the grants.
Well, I'll tell you, if you get to Chicago and there are people there that you can have extend this question to, that would be great.
Got it.
I can't answer that. Someone in the grant program can answer that question. I think it's a very, very good question. So,
Okay.
okay, I will do that then. Commissioners, there's one last matter that is not on the agenda, and I guess I can't add it, but I'll just inform you, it's not added for a vote or anything. At the last meeting, we had asked Amanda to forward over to the compiler of laws, our rules and regulations, and there's a glitch. There's a glitch. So we're going to refile it over to the legislative secretary. It's not changing the rules. It's a filing glitch. And so we will send over to the legislative secretary what was enacted under our rules and regulations previously. So we'll just have to do a refiling on that one. So it's a glitch. Our effort is to get our rules and regulations published with a compiler of laws, and hopefully if we can take care of that issue, then we're good to go. We are good to go on that one. And I believe that's the last thing on the agenda. Amanda, is there?
No, that seems to be the last
Okay.
agenda item.
And with that, I want to wish every mother a happy Mother's Day coming up. Sooner than later, I guess.
Happy Mother's Day.
Do I have a motion to adjourn?
So moved.
Second.
And we are adjourned at 3:50, one of our earliest adjournments.
Yay.
Okay.
I think clarification again on the committees.
Okay, I think we're on.
Done.
Okay, we're done. We're